are very fortunate to have with us today Melissa Kranzow. And I'm just going to tell you a few things about her before she introduces herself. She is recognized by Chambers in Global Privacy and Data Security, USA Nationwide Privacy and Data Security, Cybersecurity USA, Nationwide Privacy and Data Security, Privacy and USA Nationwide Technology in 2024, and in USA Nationwide Privacy and Data Security and USA Nationwide Technology in 2022 and 2023 for having an impressively well-rounded privacy practice, handling data breaches, as well as for being a highly regarded attorney whose broad practice exhibits strength across a number of technology-related issues and routinely advising on M&A, data security issues, and related regulatory matters. And Melissa has agreed to take questions during her presentation. So if something comes up, raise your hand, and one of our floaters will come by with a microphone. Thank you very much.
Thank you, Christine. Thanks, everyone. Can you hear me? Yes. Okay, thank you. Pete raised his hand in the back, so that's, yeah, all right. So thank you for coming. A couple of you have come up to me and said, did you speak here last year? I did. And when I spoke last year, there was only one law. It was the Colorado law. Since then, so I reapplied to speak here this year, and when I reapplied, I said, I'd like to cover the Colorado law. It's going to be amended, and I'm also going to cover a new Texas law. When I applied, California's law had not been approved and signed by the governor. And so subsequently I said, hey, California now has a law. Can I speak on that? And they said, that would be awesome. So I'm speaking about 3 laws. So just to give you a bit of how the landscape has changed and how quickly it can change. So let me advance. I've only got 5 slides. The middle 3 really are where the substance and where I'm going to focus. So what I thought I would do is give you here's where things stand right now. It's like a snapshot in time. It's not to say it couldn't change, it might change, and I'll give you some reasons why it might change. But as of now, there are 3 states with more general or comprehensive artificial intelligence laws. They all go into effect, as of now, next year. So California and Texas, January 1, 2026, a couple of really interesting things. You probably couldn't, without trying to make fun of California or Texas, you probably couldn't find 2 more diametrically opposed states, but yet they're both really populous. California is the most populous state with 39 to 40 million people, ranking not so far behind as Texas, number 2 with 31 million people. So companies, even though we are here in Minnesota, companies like to do business. They don't not like to do business with folks in these states. So I think that's why they're significant. They also have attorneys general and other regulators who will enforce. Colorado was the first, and interestingly, they were poised to amend their AI law. The governor signed it, and he kind of had signer's regret. And by the way, Colorado, you're probably wondering, I mentioned, you know, California, Texas, 1 and 2 in terms of where does Colorado rank? Does anyone want to gander what position Colorado is and how many, or should I give you that info? 20th, with nearly 6 million people. Minnesota, slightly under 6 million, is 22nd. A little bit of trivia. If you added the populations of California, Texas, and Colorado, and divided it by the population of the US, it would be 22% of the population, which is, that's not insignificant. I'm talking also, in addition to talking about number of people and rankings, I'm also talking about the timeline. So I mentioned Colorado's governor signed the original version of the law that I spoke about, but he kind of had signer's regrets, and other people did too. There were different groups that said, we really want to revise it. So Colorado held a special legislative session at the end of the summer. And the only thing they agreed on was literally extending the effectiveness. A year ago, I was here telling people it's going to be effective February 1, 2026. Now it's going to be effective June 30th, 2026. What an odd extension. Why did they do it that way? Well, there will be a legislative session in Colorado before June 30th. So the thinking is, as opposed to a sort of a special session that was very, very short and maybe too short for the different groups to have agreement, they may have more time during the legislative session. So one of my, I'm going to try to give you some themes to look at. One of them is stay tuned for developments. So Colorado's may change. Another thing, other states will have legislative sessions. There may be more laws. And one other thing that I think is really important, and I think is shown by Colorado, just because you have a law doesn't mean it can't be further amended. And this happens in the world of privacy, data security, and data breach. These are living laws, and you have to really keep your eye on track developments because there may be changes, including increasing the scope of the law. So another really interesting thing, and there was an artificial intelligence legislation floating around Texas, of all places, sort of not the most, they don't maybe like or embrace regulation, say, the way a California would, but interestingly, it passed and it got signed. And the timing was, you've heard of the One Big Beautiful Bill. I'll try very hard not to bring politics into this. One provision of the One Big Beautiful Bill that did not proceed, it failed. There was going to be a 10-year moratorium on state artificial intelligence regulation. And at the last minute, and what was really interesting also were, it wasn't just a particular group or a party, there were different affiliations that said, wait a second, this may not be such a good idea. So there's different views, but in the wake of that, Texas's governor signed this bill, which I thought was intriguing. And then California, so then you had the One Big Beautiful Bill, this 10-year moratorium against state AI regulation stripped out. End of August, Colorado legislative session, we're going to amend it. It's going to go into effect. The Colorado AI law going to go into effect now, June 30th, 2026. Then at the end of September, in California, California's governor had vetoed an AI law. He signed a different one. And that happened literally at the end of September, so hence applying for this and then finding out that California had their law. So you've got links in my slides, and if you need my slides and you don't get them, email me, I'm happy to provide. So these are links to the laws. I note on Colorado, I'm gonna try to use the red light. Oh, there we go. There are two links. That's the law. That's the amendment to the law. The gist is the amendment says effective date June 30th. I'll try not to say that too much more often. Stepping back, are these laws the same? Absolutely not. That's what's fascinating to me. There are maybe more differences than similarities. So I'm an attorney. One thing I constantly look for is there required contract language? No, there's not. Who does the law apply to? So who's covered by this law? These are all different. So let's go through how this applies. So California, like many things in laws in California, is really unique. It applies to a type of a frontier developer. And then there's a distinction. There's a regular frontier developer and then kind of a subset, which is a frontier developer, but it's treated, I think it's regulated a bit more as a large frontier developer. So you're probably saying, what's a frontier developer? Well, that gets me to the next point. That's a definition, and there are definitions within definitions. So in California, a frontier developer is a person who's trained or initiated the training of a frontier model, which is defined. A frontier model is a foundation model. which is an artificial intelligence model trained on a broad data set designed for generality of output and adaptable to a wide range of distinctive tasks. Okay, frontier model, that was trained using operations including computing for the, that was trained using a quantity of computing power greater than 26 integer or floating point operations. It's a mouthful, so there are definitions within definitions. Key way to look at these, you have to look at the definitions. Each of these laws, they're very important. So you're probably saying, what's a large frontier developer? That's a frontier developer that together with its affiliates has annual gross revenues in excess of $500 million in the preceding calendar year. You're probably saying, that's a lot of money. With providers of AI that you've probably heard of, that's not so much. So another comment, Anthropic, which would qualify, publicly voiced its support for the California law. OpenAI, which also would qualify, didn't say anything. The sense is that it would prefer federal regulation. And then, you know, this would cover, if you will, the Googles and the Metas of the world. So if you think of who is a big name, it would cover them. If you think of a startup, it probably wouldn't cover them, although a very successful startup can become quite successful. So there is a distinction. Texas takes a different approach. It applies to anyone who basically conducts business in Texas, any person. That could be anyone. It also could apply, these are in the alternative, produces a product or service in Texas. That's kind of broad. Here's the other interesting, or develops or deploys an artificial intelligence system in Texas. And you're probably thinking, I wonder if develops or deploys or artificial intelligence system is a defined term. Best 1 out of 3. Artificial intelligence system is defined, and I'm very happy to tell you, and it's one of the similarities, artificial intelligence system is defined the same way in both Texas and Colorado. That's, otherwise the laws are very different. Colorado uses the develop and deploy, except Texas, while it talks about it, a verb, develops or deploys, Texas uses it in a defined term as a noun, deployer, a person who deploys an artificial intelligence system for use in Texas. Developer, a person who develops an artificial intelligence system that is offered, sold, leased, or otherwise provided in Texas. So you're probably saying, what's an artificial intelligence system, which would satisfy, which is the same definition for both Colorado and Texas. That is any machine-based system that for explicit or implicit objective infers from the inputs the system receives how to generate outputs, including content, decisions, predictions, recommendations that can influence physical or virtual environments. So when I was speaking last year, this was the definition under the Colorado law. There was only the Colorado law. Interestingly, Texas also applies a lot, the Texas law, to governmental entities. It's what you think it would be. So Colorado also applies to developers and deployers, but there is a distinction. There is a distinction between how they're defined. They also make a distinction between the artificial intelligence system, remember, same definition as Texas. Colorado also defines high-risk artificial intelligence system. Okay, so the deployer is someone in Colorado that deploys high-risk artificial intelligence system. Developer does business in Colorado, and this is with regard to not high-risk artificial intelligence system. Developer means a person doing business in Colorado that develops or intentionally and substantially modifies an artificial intelligence system. Wait a second. Yep, you guessed it. Intentional and substantial modification, it's defined. And further defined within the definitions is making a consequential decision and a substantial factor in making a consequential decision. So as you can see, these all apply differently. The defined terms are different other than artificial intelligence. I'm on my third and last slide. So what I'm now going to do is sort of the view from 30,000 feet. What do the laws do? What do they require? Again, these are completely different. So I'll go through each one. California, remember, frontier developer and large frontier developer. The distinction here is large frontier developers have a lot more requirements, which would kind of make sense. So in other words, they're making a distinction. It might be more difficult for a smaller entity that's a mere frontier developer to do things that they're requiring of large frontier. Some laws make this distinction. When you are a smaller business or a startup, in some ways, it's easier to comply. You don't have maybe as much organizational complexity. Decision-making might be easier. You might do things that are in your own self-interest. You may not even have a legal department, and you can just go ahead. A large organization on some levels has advantage. They may have a legal department, they may have budget, but they might not have that much budget. And there may be different voices beyond a legal department, different functions, IT and other functions who want to do certain things. So decision-making may not be as easy. But in any case, a frontier developer, so this includes a large frontier developer, but everyone has to clearly and conspicuously publish on the internet a transparency report. Everyone has to report critical safety incidents. So before this session, Christine J., who has the microphone, she said, Melissa, are you going to talk about data breach? And I love talking about data breach. It's part of my practice. I'm going to make an analogy because she gave me the perfect segue. Critical safety incident. So you have to report critical safety incidents on your frontier models to the California Governor Office of Emergency Services. This is the Governor's Office of Emergency Services. What's fascinating, and it's different from data breach, although it could happen. So in a data breach, if you have a breach, if you're a company, you have to do a couple things. In every state, there are laws in every state, you have to report to the affected individual. In many states, you have to report to a regulator, usually the Attorney General. It can differ. Here, if you think about it, a critical safety incident, you have to report it to the Governor's Office of Emergency Services. Interestingly, a member of the public can also make this report. The analogy is, well, it's not under our data breach laws. If you think you feel aggrieved or you feel like the Attorney General or other regulators should know, you can report. Like there are usually forms. There are forms, I believe, on the Minnesota Attorney General's website and on other Attorney General and other state regulators' website. In other words, anyone can put in that report, and that's how the government knows something's not right. So you're probably saying, well, what's a critical safety incident? So again, a defined term, unauthorized access to, modification, or exfiltration of the model weights of a frontier model that results in death or bodily injury, harm resulting from the materialization of catastrophic risk. Yes, a defined term. Loss of control of a frontier model causing death and bodily injury, and a frontier model that uses deceptive techniques against the frontier developer to subvert the controls or monitoring of its frontier developer outside of the context of an evaluation designed to elicit this behavior and in a manner that demonstrates materially increased catastrophic risk. There's that defined term again. What is it? It's a foreseeable and material risk that a frontier developer's development, storage, usage, or deployment of a frontier model will contribute to the death or serious injury to more than 50 people or more than $1 billion in damage to loss of or property arising from a single incident using the frontier model. That's a big deal. One thing I've noticed, if you're going to use the data breach analogy, it doesn't take that much to trigger a breach notification. It seems like it might take a lot more to trigger this critical safety incident reporting. That's something to keep your eye on. That would be newsworthy, and anyone can alert the governor's emergency service office. And what I usually say in the data breach context, people are random and subjective. One aggrieved person isn't going to contact a regulator, others will. Others will, whether there's a law or not. If there's something they think is wrong, they're going, and it can be anyone. So it's interesting. And then the office will have to make a determination. Do we want to pursue this? Do we want to investigate this? So the other thing all frontier developers have to do is, I'll use a general term, they have to provide whistleblower protections. Why is this important? If you think about some of the larger technology companies, a great example I will pick on Meta, Facebook, there was a whistleblower. And so California is explicitly providing whistleblower protections in the AI context. So in other words, if someone's to go and make a report, the protections, I don't know if it's an incentive, but in other words, you're not hopefully going to experience retaliation. You still may, but you could maybe challenge it. But in other words, you're given protection by the law, which is also, I think, kind of unique. Okay, so the large frontier developers, what are their additional responsibilities? They've got to include extra information in their transparency report. I won't go into it, but feel free to come up afterwards. Again, a large frontier developer has to communicate with the Office of Emergency Services if of any assessment of catastrophic risk resulting from internal use of its frontier models every 3 months, or another reasonable schedule. So they'll be constantly communicating with that office. Fascinating. In other words, in internal processes and in making their own assessment about catastrophic risks. And then what's really interesting, in the penalties section, this is enforced. It's enforced by the California Attorney General. If a large frontier developer makes a material or misleading statement about catastrophic risk from its frontier models, or it doesn't, or about implementation or compliance with its AI framework, it will be subject to a civil penalty that doesn't exceed $1 million per violation. So the Attorney General, who is out enforcing a lot, they now will have this as of January 1st. So let's go to Texas, completely different jurisdiction. This is an incredibly unique law. The legislation went through several drafts, and people said at the end, the obligations were less, if you will, but there still are obligations. So a couple things. A lot of obligations are on government entities, not like a private company. So I'm not going to go into them, but come up or email me if you want to learn more. What does it say for private entities? So Texas doesn't use, it uses the word person. So, and it uses the verb. So a person cannot deploy or develop an artificial intelligence system. They don't have high risk artificial intelligence system like just artificial intelligence that intentionally aims to incite or encourage harm to another person, physical self-harm or criminal activity. They can't use an artificial intelligence system with the sole intent to infringe, restrict, otherwise impair an individual's rights under the US Constitution. They can't use this to unlawfully discriminate against a protected class in violation of state or federal law. Finally, they can't use an artificial intelligence system with the sole intent of assisting, producing, or distributing visual material or deepfake videos or images in violation of Texas Penal Code. In a nutshell, some people have called this child pornography. There's other provisions. But you'd have to read the specific Texas, or intentionally develop or distribute artificial intelligence system that engages in text-based conversations that simulate or describe sexual conduct while impersonating or imitating a child younger than 18 years of age. That's it for private companies. Okay, Texas Attorney General, who is out enforcing privacy and data security, enforces this. So do Texas state agencies, and the penalties are stiff. You're given an opportunity to cure a violation. If it's curable, a penalty could be between 10 and 12,000 per violation. If it's not, if it's uncurable, between 80,000 and 100,000, 80,000 or 200,000. And then between 2,000 to 40,000 each day a violation continues. So there can be multiple violations. It can continue over the course of days. This can amount to a lot. And then after the Texas Attorney General enforces, they can recommend additional enforcement by an appropriate Texas agency. So hence, this law covers a lot of things that Texas regulated entities are subject to. May impose additional sanctions on a licensed, registered, or certified person, including monetary penalty not to exceed $100,000, and suspending, probating, or revoking a license, registration, certificate, or other authorization to engage in activity. So, and I think they'll enforce, is my prediction, based on how they're enforcing other related technology areas, including privacy and data security. Colorado, as I said, I thought, oh, this is great. All I have to do is change the effective date. But I still actually went back and reread the law. So there are numerous obligations. As I said, deployer is high-risk artificial intelligence system. And then there's developer, artificial intelligence system, not high risk. So deployer has to implement a risk management policy and program to govern their deployment of the high-risk AI system. A deployer or a third party contracted by deployer that deploys a high-risk system has to do an annual impact assessment for that. Deployer or a third party contracted by the deployer must review this and ensure that it's not causing algorithmic discrimination. Another important word. So if you think of critical safety incident under California, this is the defined term under Colorado. Algorithmic discrimination. Different, but it's important. It means any condition in which the use of an artificial intelligence system results, not high risk, any artificial intelligence system results in the unlawful differential treatment or impact that disfavors a group or individuals on the basis of their perceived age, color, disability, ethnicity, genetic information, limited proficiency in the English language, national origin, race, religion, reproductive health, sex, veteran status, or other classification protected by state or federal law. And then there's carve-outs from this. I won't go into this. And if there's a consequential system, yes, a defined term, there's certain disclosures a deployer's got to make. And if there's an adverse decision, there's more statements and disclosures they've got to make. And then a deployer also has to put on its website a statement summarizing the types of high-risk artificial intelligence systems they're currently deploying, how they manage known or reasonably foreseeable risks of algorithmic discrimination, and talk about the nature, source, and extent of information collected and used by the deployer. And they've got to use, the deployer has to use reasonable care to protect against bad things or risks from algorithmic discrimination. And here's the analogy to critical safety incident, telling the regulator something's wrong. If they discover high-risk AI system has caused algorithmic discrimination, they must, without unreasonable delay, but no later than 90 days after the date of discovery, let the Colorado Attorney General know. So if you think about it, again, a report of something bad to the state regulator, in this case, the Colorado Attorney General. And a deployer or other development that offers, sells licenses, it's got to do a disclosure with a consumer that they're interacting with an AI system unless it's obvious. Developers now of a high-risk AI system will make available to the deployer or other developer disclosures. And this is so that the impact assessment can be completed. And developer will make on its website or in a public use case inventory a disclosure. And developer of a high AI risk system will disclose to the Colorado Attorney General and to all known deployers or other developers of a high-risk AI system any known or foreseeable risks of algorithmic discrimination. There's that word again. And developer will also use reasonable care to protect consumers for any known or reasonable foreseeable risks of algorithmic discrimination. So Colorado's Attorney General, who is out enforcing, they have exclusive enforcement authority, and a violation of this law constitutes an unfair trade practice in Colorado. I said another thing I'm going to say is stay tuned for developments. What do I mean by that? So these are sort of cliffhangers to my presentation. Will the Colorado law be further amended by the Colorado legislature? Will all the different parties who wish to amend this finally agree? Will it go into effect June 30th, 2026? Stay tuned. I'm really interested to see what happens in terms of enforcement of these laws. Interestingly, California and Texas will go into effect first. If I had to make a bet, I think Texas will have the first enforcement action. It's not to say California won't enforce, but Texas, when a law is enacted, a good example is privacy. I think there was quicker enforcement. And there's different views of enforcement. And then will there be other state AI laws? Maybe. Will these laws that I'm talking about today be amended? They could. Colorado is maybe an obvious one, but it's not to say Texas or California couldn't be amended. And then I'd like to get to a point, and you came up to me also, and I'm forgetting your name. Michelle, thank you for reminding me. So Michelle came up and said, my business partner just attended an event where they spoke on insurance regulation of AI, and I said that's a really good segue. So I'm going to flip-flop what I was going to say. There are other laws and other regulators that regulate AI. It's not just these three. Oh, 10 minutes. One really good example in the insurance area, you may or may not have heard of something called the New York Department of Financial Services. Okay, it's a big deal. It's an insurance regulator, it's a financial services regulator, so a lot of things are under its authority. It tends to be in the forefront. Really interesting. Just within the past month of October, they issued cybersecurity guidance. October was Cybersecurity Awareness Month. And what they said is, the entities we regulate use a lot of third-party service providers. Which company really doesn't? They all do. And they said they specifically called out artificial intelligence. They talked about cloud computing as well, and they said, where relevant, the entities we regulate should consider a clause related to the acceptable use of artificial intelligence and whether their data may be used to train AI models or otherwise disclosed to additional parties. So there's guidance recommending contract language. As I think I said at the beginning, if you look at the California, the Texas, the Colorado AI law, there is not required contract language. And I went through the obligations. There's not required contract language. It's not to say you yourself couldn't come up with something that's based on those laws and say, hey, the Colorado law says this, I'm putting this contract. But it doesn't expressly say you should have contract language. New York Department of Financial Services is giving an indication of what it might expect to see in a contract with an artificial intelligence service provider. The other really interesting development, so one thing these three states have in common, other than having these AI laws, you've probably heard of the consumer privacy laws. Minnesota has one. It went into effect July 31st. Maybe you don't know. A lot of people don't seem to know that. But you've probably heard of a law called the California Consumer Privacy Act, the CCPA, as amended by the California Privacy Rights Act. So that is a big deal. It was the original law. It's both a law and regulations. What am I making a point about? On September 23rd, regulations were approved that relate to something called automated decision-making technology. Nowhere in this is the word artificial intelligence, but I think there's an implication for artificial intelligence. Its requirements for automated decision-making technology, which is technology that processes personal information and uses computation to replace human decision-making or substantially replace human decision-making. businesses that use this have to comply with a number of requirements, giving a pre-use notice, allowing opt-out of the use of this technology, and responding to consumer requests about this technology. The regulations, think about our timeline, go into effect January 1, 2026, which is when the California Artificial Intelligence Law goes into effect. But interestingly, it's businesses that use automated decision-making technology to make significant decisions, and that's a defined term, must comply with the requirements beginning January 1, 2027. Okay. And then, so in other words, even though these regulations go into effect January 1, they don't have to start complying until the following year, January 1, 2027. Okay. So another good example, Texas also has a consumer privacy law. And the Texas Artificial Intelligence Law amended that law. And there is the word artificial intelligence. So what it said was, that law talks about a controller like a business, and a processor, if you will, is its service provider. And so it said a processor, the service provider to a business, must help the controller, the business, with regard to complying with requirements regarding personal data collected, stored, and processed by an artificial intelligence system. And yes, it's the same definition as under this Texas law. And then finally, California, in its regular law, they amended that law, and they talk about the form of personal data. That could be personal information under the CCPA can exist in various formats, physical, digital, or abstract formats, including artificial intelligence systems that are capable of outputting personal information. I have 5 minutes left. So the point I want to make here is there's lots of different ways artificial intelligence is regulated. The automated decision-making example, you don't see, like if you're doing a word search, that doesn't say artificial intelligence, but in terms of the functionality, I think there's an application to be had. Other laws, and I'll give you the Minnesota example, we have a consumer privacy law. It went into effect July 31st, 2025. One of the, and there's nowhere in there are the words artificial intelligence, but what is in there is, as an obligation, the business is not going to, I'm paraphrasing, unfairly discriminate under state or federal laws. Other states have this, by the way. What I do when I'm representing a company is if they have a vendor, I will push it to the vendor and make them agree what the services they're providing under the agreement will not unfairly discriminate. I'll take the language right out. It's not technically required, but if you're representing the business, you'd probably want to push it to the vendor. If you're the vendor, you'd say, hey, that's not required contract language. You'd push back. Why am I agreeing to this? There may, depending on the respective parties' leverage, there would be some agreement. Maybe the language is in, maybe it's modified, maybe it's out. My point is, if you look at the word discrimination, that would be another trigger, and these are under the privacy laws. Last point, Colorado, Texas, California all have consumer privacy laws. So that's, and now they all have artificial intelligence laws. And like the Texas example, they kind of work together, like they used artificial intelligence system from the Texas AI law. So this area, everyone was trying to keep up with the consumer privacy laws, and now there are these artificial intelligence laws. Last, stay tuned for development. So I mentioned the 10-year moratorium, which got stripped from the One Big Beautiful Bill. I don't think this is the end of this conversation. There is a back and forth, who should be regulating privacy and data security? Should it be at the federal level or should it be at the state level? For years, there's been a chorus of voices. We need one law. It's really unfair to have companies have to look at these different state laws, but that's where we are. Interestingly, if you look at artificial intelligence, it's proceeding along the state law path. And there's, I think, in our current political environment, and I'm trying very hard not to make further comment, there's sort of a tension. Who's going to regulate? Federal, state, potentially both? So stay tuned for developments. I have 2 minutes left. I'm happy to entertain any questions you have. Yes?
So these laws have started with these 3 states right now. Do you see this trickling down to other states within the United States?
Yeah, I think, so stay tuned, the legislative session in the coming year. And we don't, so my other comment is you sort of don't know what will happen. You're like, that's going to pass for sure. And if the privacy laws are any indication, there were states, I'm like, that state's going to have one, that state isn't. And I've been completely wrong. And so, as I said, I tried to give you context, like Texas got signed in the middle of, we're going to have a moratorium, federal, it didn't happen. So I think 2 things to look at, whether the state law gets passed, and like Colorado does, and by the way, to your point, it's a really great point. Governor Newsom vetoed legislation, and Glenn Youngkin, different political leanings, he vetoed it. So that was all, like, in other words, just because a law is passed by the legislature, the governor can veto it, or in the case of Jared Polis in Colorado, he can sign it and then have signers, which is actually even more unique. And then we'll see what happens in Colorado. Does that, but I'd say stay tuned.
Because this is an ever-changing environment right now, are there any resources for news that you like the most, that are good places to look?
Yes, and you actually, that was one of my, what if the audience doesn't ask questions. So thank you for the softball. So I am a privacy attorney. There is a group that you may have heard of called the International Association of Privacy Professionals. Not to give it a plug, but I'll give it a plug. It offers certifications, including a very highly and new sought-after artificial intelligence governance professional, which I don't have. I have the privacy certification. They have a daily email. You don't have to be a member. It's on their website. They also have an artificial intelligence governance newsletter. In terms of legal developments, I look at that. I like the Wall Street Journal's coverage. I think they do a very good job. The Wall Street Journal, in addition to its main coverage, they also have specialty publications. Like there is a cybersecurity newsletter, which I think you can sign up for. Whether you get access to the whole article, you may need to subscribe, but I think really, really good reporting as well. The other thing, I think sort of the power, look at what the regulators are saying. So I would go to the New York Department of Financial Services. I mentioned they came out with these, you entities that we regulate, you use third-party service providers, and here's some artificial intelligence language. They came out with artificial intelligence guidance a year ago. I would look at now the California Attorney General, the governor's office. I would look at the Colorado AG. I'd look at the Texas AG. I know you can subscribe to the news releases from the California AG. And anyone else?
So is there any lobbying against this type of regulation, or is it more lobbying against the details within it? Do you know what I'm saying? Like, are people saying, we know we need to have these, so we're just going to get into the details, or are people trying to push back on the whole concept?
Both. And I think it depends on, there are different groups with different interests. So you would have large technology companies. I mentioned the Anthropic example because it was, you didn't see other large frontier developers saying, hey, we want to be regulated, and Anthropic did it. Anthropic probably did it out of self-interest, not to be cynical, and to distinguish itself from the other providers. So there's a reason I think they did what they did. But I think, and it doesn't always fall along it does not fall along necessarily on political lines. I think parties of less regulation, it's where you'd expect, but there were Republicans who were critical of the moratorium on the AI and said, you know, this is like very important and we can't just, if you will, throw the baby out with the bathwater. In terms of details, that's a great example of where I think Colorado couldn't, in a short special session, get things I guess, amended to everyone, and that is why we don't have federal privacy law and why we don't have federal data, I mean, except in regulated areas, and probably why it's the states who are taking it upon themselves to regulate. So, does that answer your question?
These are great questions, everybody. Thank you so much. We have to get going because we're having a room changeover. But see if you can follow Melissa out the building and ask your question. Melissa, thank you so much for speaking with us today.
Thank you, Kristen.